Hi everyone, we welcome you back to our channel. This is Legal Mindset at the Bar, and today we are continuing with our topic of mistake, and it is a topic in contract law too. We are going to look at the principle, the plea of non-est factum, the documents mistakenly signed. So we are continuing. I told you, unilateral mistake may arise as to the nature of the document signed or sealed. So we are going to look at non-est factum in a way that we are going to see the general rule. We shall see the general rule. We shall see the persons who can rely on non-est factum. We shall look at the Illiterates Protection Act. We shall look at people who cannot rely on the principle of non-est factum. We shall also see the position of different judges on the principle of non-est factum. To dive into it, I beg you to subscribe such that we can continue. So let us dive into it. The principle of non-est factum. It means that documents mistakenly signed. So the general rule under documents mistakenly signed, a person is bound by his or her own signature to a document, whether or not they have read or understood the document. So colleagues, I beg you to be very keen on what documents you sign, because you're bound by your signature, whether you read the document or you did not read it, as long as you sign. So the plea of non-est factum means you have signed a document by mistake, where a person has been induced to sign a document or a contractual document by fraud or misrepresentation. That transaction is voidable. But courts are generally hostile towards the applicability and the reliance on the plea of non-est factum, because they take the position that persons of full age and sound mind who voluntarily sign documents should not be lightly allowed to rely on non-est factum. You can see you are of sound mind. If you look at contract law, it is based on two principles: the doctrine of freedom of contract and the doctrine of caveat emptor. Caveat emptor means that it is not the business of court to protect a buyer who signed or who entered the contract without minding sleeping on their rights. It means that you should take reasonable diligence to the nature of the document you are signing. Court will not come in to protect a person of sound mind, a person of full age who signed the documents negligently. But however, courts have put up ways in which a person can rely on non-est factum. You should prove these conditions before urging, before begging to be shielded under the shadow of non-est factum. And if you go to the case of Saunders versus Angalia Building Society, case reported in 1971, in that case, the House of Lords held that for a party to rely on non-est factum, the party must have taken reasonable steps to understand the nature of document they are signing. You should explain it to court that this is the nature of document I was signing, and that you also took reasonable steps to find out that yes, it is the document you are signing, for you to rely on non-est factum, for a contract to be held voidable because you mistakenly signed the document. And the plea of non-est factum is available to a limited group of people. persons who may not be able to read and understand documents are the only people who can be relieved by the plea of non-est factum. You can look at the persons of unsound mind, the minors, the illiterate, persons who are at the time of signing intoxicated. You can also look at the senile. The senile are the very old people who cannot see. So if you go to another condition, you should prove that the mistake was so serious in a sense that it must relate to the character of the document and not merely its exact content. I urge you colleagues to go and read and invest yourself in the case of Saunders versus Angalia Building Society if you are to understand the plea of non-est factum. Another one is that the document was misrepresented. Person comes to you, they tell you to sign, they tell you other things instead of the real contents in the document. And if you go to the case of, okay, let me explain deeply. If you are signing a document with a person who cannot read, you should explain to them tentatively the nature of the document they are signing. You should make them understand what they are signing. You should not misrepresent them. If you misrepresent them, they can rely on non-est factum to make the contract voidable. So, in the case of Kasala Growers Cooperative Society versus Kakoza and another, what held that a person writing a document with another person who is uneducated must explain properly the contents of the document to that other person to understand the nature of document they are signing. You get? So, we are going to look at, we have said if the document is misrepresented, a person can rely on non-est factum. So, we shall look at the position of the Illiterate Protection Act on the plea of non-est factum. So, the Illiterate Protection Act protects some people, but however, it also does not protect some people, as Justice Stephen Mubiru held in the case of Opia Moses versus Rukia, Roslyn Romango, and others. It is High Court Civil Suit number 22 of 2013, and one of the most good judges in the country, Justice Stephen Mubiru, held that a person who does not know English but claims to understand the contents of the document they are signing is not protected by the Illiterates Protection Act. So, for an illiterate to rely on non-est factum, they must prove many things. Because you are illiterate, but you are of sound mind. You are not senile. You can see. It means you have due diligence, according to the doctrine of caveat emptor, to take reasonable steps, maybe to call your lawyer to describe to you the nature of document you are signing before you claim to rely on the plea of non-est factum. And if you go to the case of Kakande versus Nsimbi, what held that? Let us first look at Lewis versus Clay. In Lewis versus Clay, what held that the illiterates will not rely on non-est factum if it is shown that he or she would have known the contents of the document if they took reasonable steps or if they were not careless. You get, colleagues? For an illiterate to rely on non-est factum, you must prove that you were not careless. You took reasonable steps to know the nature of document you are signing. So, that principle was later used in Kakande versus Nsimbi, where an illiterate sale of land would not take advantage of non-est factum because it never bothered to ask his lawyer to translate the document he was signing. That is the plea of non-est factum. It is a technical topic, it is sacrosanct and very important in your understanding of contract law too. So, I beg you to subscribe to our channel such that we move together. And if you have found this video helpful, forward it or share it with your colleague such that they also join the family. Thank you very much. This is Legal Mindset at the Bar.